May it please the court, my name is Lisbeth Alvarez, and along with my co-counsel Emma Favela, we represent the petitioner in today's case, the state of Florida. There are two questions before the court. First, whether the law's content moderation restrictions comply with the First Amendment, along with whether the law's individualized explanation requirements also comply with the First Amendment. We will be addressing the following issues with the following 3 points. First, social media platforms themselves do not convey a specific message in regards to their platform or brand. Instead, social media is used more as a modern-day bulletin board. Second, social media should be treated as a common carrier. And third, the social media content moderation restriction law does not infringe on its community guidelines. It solely adds restrictions on the protocol after content moderation has already taken place and eliminates political bias. Moving to our first point, social media themselves do not convey a specific message in regards to the image of their platform or brand. Instead, social media is used more as a modern-day bulletin board. The court should find that social media platforms cannot be held at the same standard as those of a usual business, as they differ in a variety of ways. First, as a usual business, its goal is to create and uphold a specific image of such brand, and many times the ultimate goal is to uphold such branding. However, when it comes to social media, it's used more of a way for exposure. Furthermore, they mainly host ideas from third parties within their platform, meaning that the court should fail to see these social media companies as private actors, as third parties who regularly interact within the platform themselves are the face of such company, which at its core is the reasoning as to why they are so different from that of a usual business. Moreover, the court should find that social media platforms to be common carriers. This means that the company accepts the general public without any discriminatory regulations, making it open to the general public, which Supreme Court Justice Clarence Thomas noted during Biden v. Knight that companies cannot be treated as publishers for information that they merely distribute. This would be severely different as that of a newspaper, who have an editor who has to manually approve articles in order to uphold the standards of such companies, with the differences of that of a usual business. Serve reasonable belief that social media companies are not private actors. Additionally, even if the court chose to view such media platforms as private actors, all protection of fundamental rights will always have exceptions in order to protect the general well-being of the United States citizens, such as the Fairness Doctrine, which established that content moderation itself does not bar social media companies from all creative freedom, simply the exposure of certain content. Therefore, the limits based upon the media by the state of Florida is consistent with the U.S. Communications Policy of 1949. Due to social media being able to express their creative freedom in other aspects, means that there is no real threat to their creative freedom, as many social medias themselves have an account within their creative platform where they are able to have full creative control over, meaning media companies are still able to actively express support and share ideologies that they would like to be seen in support of. Finally, the rules related to the cancellation or suspension of a user account users are warned that their content and account may be suspended if they are caught breaking or harming the community. Additionally, social medias are more advanced and have been recently developed, meaning they should be treated differently. For example, since technology advancement, users are able to upload posts within seconds from the cellular device. The social media platform have no control on what the users post and can only take down the post when going against community guidelines. Seen in Biden v. Knight, unlike newspaper, digital platforms hold themselves out as an organization that focuses on the distributing of speech of the bordering public. Also seen in Biden, federal law dictates that companies cannot be treated as the publisher or speaker, furthermore proving that social media platforms do not convey a certain message. However, they host other users' posts and messages.
Additionally, social media platforms cannot be held at the same standard due to their subjects within society in comparison to those of usual business. The content moderation simply prevents a biased form within the media which is something regularly consumed by not only Americans, the modern world as a whole. Moreover, various studies have been shown the growing influence of media consumption within today's society. Based on the article of Most Americans Think Social Media Sites Censors Political Views, throughout the years, through the article conduction of statistics, it has found that 66% of Americans believe that media censors certain political ideology and do not trust the media labeling of inaccurate and misleading. Moreover, the court should find the reliance of such platforms in regards to the selectivations of ideas and views not only within the general population, but especially in younger generations who identify and ideology is actively being built, which is another critical reasoning for the court to hold social media as a different standard than the usual business. A study by Forbes called How Important is Social Media in Young Voters? The article explains how critical the social media is in terms of reaching larger and new and more diverse audiences, especially the younger generation, or our soon-to-be voters. The article goes on to say that because of the bias within social media and censorship of certain political views, with liberals saying in their lane with Twitter, while conservatives' voices have been increasingly moved to prior as their de facto platform. The court should find that unless the platform is made with sole idea of spreading a specific ideology, they may not take active bias through post prioritization or shadow banning on posts. Moving on to our second point, social media platforms should be treated as common carriers. Common carriers are companies in which are open to the public and must accept all. Additionally, according to the First Amendment, common carriers and public accommodations by Justice Thomas defines common carriers as affected with the public interest, whether entity regulated is part of the transportation or communications industry, whether it receives countervailing benefits from the government, and whether the actor holds itself out of as providing service to all. Within the case at bar, the description of common carriers, social media platforms are affected with the public, such as the public is using the platform to express their interests and thoughts. Social media platforms also are regulated with communication, ranging from comments to direct messages between users. Additionally, due to technological advances in our present days, social media platforms can be held as common carriers. As seen from Biden v. Knight, in many ways, digital platforms that hold themselves out to the public resemble a traditional common carrier. Also seen in the case of Biden v. Knight, it begins to discuss the comparison of telephone companies and social media platforms. For example, both digital platforms and telephone companies have a system where they carried out information and helps people communicate. Furthermore, the state can force social media platforms to become common carriers. Although others argue that social media platforms are not common carriers, the state can still treat them as common carriers. As seen from Biden, even if digital platforms are not close enough to common carriers, legislators might still be able to treat digital platforms like places of public accommodations. Additionally, Justice O'Connor states in Turner Broadcasting v. FCC, it stands to reason that if Congress may demand that telephone companies operate as common carriers, it can ask the same from digital platforms. In conclusion, social media platforms are common carriers and the state can treat them as such. Now I'll be passing it to my co-counsel Liz Alvarez as she will suggest the last point.
The social media content moderation restriction law does not infringe on the community guidelines. It solely adds restrictions on the protocol after content moderation has taken place and eliminates political bias. Based on the social media construction law itself, it does not change the social media platform's community guidelines, which serves as an outline between acceptable posts and topics and those which are considered inappropriate and unacceptable. However, it does create a politically biased free platform, allowing both liberal and conservative candidates to utilize the exposure to the full extent. Furthermore, the media constriction laws remain neutral while actively targeting political biases within modern day social media, such as stating that social media cannot limit the potential exposure or shadow ban post that was created by or about a candidate, meaning unless a post itself directly abuses what the social media has written within their community guidelines, whether it promotes or is critical of a political candidate, it cannot be removed regardless of political party. The laws also state that the media platforms must apply consistent constriction laws in a consistent manner, which simply ensures that users are safe within the platform to share, express, and promote their ideology so long as they are within the platform's guidelines. Additionally, through the detailed and personalized explanation as to why posts or accounts themselves are being limited in regards to potential exposure, allows the company to keep their online community safe while defending their community guidelines. Through a thorough explanation of why a post is deemed inappropriate to the general population, allowing the online community to remain safe while being online with a multitude of other individuals. The purpose of this law is not simply to push right-wing political views, but prevent the learning of reasoning behind such ideology. As social media will only have a greater impact on society, it's important to keep the most relied upon source of information unbiased, so that current and future generations are able to develop their own opinions and ideologies, that the foundation was not the sole purpose of the media restricting them, especially if it doesn't violate their community guidelines.
To conclude, the court should find that social media companies are not consistent with the standard of being considered are not consistent with being a standard as a private actor, as they differ in multiple ways and of those of other businesses. Additionally, the court should look at social media's companies as common carriers over being a private actor. If the court does not find that social media platforms to be private actors, then it should look into the fairness doctrine to assess the social media content moderation restrictions and laws, which remain neutral and severe to protect the general well-being of those who regularly consume and interact with social media, and prevents the restrictions of potential exposure within the media, as the impact in today's society in grand. It is for these reasons that we pray that the court rules in favor of the petitioner and reverses the lower court's decision.
Now we will be addressing questions.
Counsel, why is social media so important today?
Social media has undoubtedly become a necessary daily activity in modern day society, as we regularly interact with it, whether we are communicating with one another or learning information or simply keeping up with our pet or with our peers. Additionally, it is a very efficient way to keep the spread of critical information rapidly. Social media allows us to keep in touch with not only others, but many events taking place within our worlds, which many individuals severely rely on. Based on Statia's study on media urge in the U.S., American on average spent 8 hours with digital media. Statia also did another study concerning fake news within the media that us Americans rely on to receive information. The study revealed that just under 80% of social media consumers reported witnessing false news involving the COVID outbreak in 2021, and the study also revealed of how troubling fake news is to get in control of as an information is able to reach a large audience before being deemed as false or unreliable. Additionally, 40% of respondents to statistics revealed that they themselves are unknowingly spread false information to others.
How does the Florida law restrict social media platforms' ability to engage in content moderation by removing, editing, or arranging user-generated content?
Florida's law has allowed social media platforms to remove and edit users' posts. However, social media platforms must notify the user and give reasoning behind their actions, which the reason usually must be due to the content that was being posted wasn't within their community guidelines. For example, found in the center of Instagram, it states, "We create the community guidelines so you can help foster and protect this amazing community. By using Instagram, you agree to these guidelines in our terms use of condition. We are committed to these guidelines and we hope you are too. Overstepping these boundaries may result in deleted content, disabled accounts, or other restriction." The law has affected social media platforms in a positive way by allowing the platform to delete any content that may be violent or harmful to the public. Some example of these groups being nudity, terrorism, organized crime, hate groups, or hate speech, bullying, harassment, and graphic violence. This overall helps the community by removing anything harmful to keep the platform a safe place for the public.
How does Florida's laws require social media platforms to provide individualized explanations for certain forms of content moderation?
The Florida law requires social media platforms to give a brief explanation when any form of content of moderation. Furthermore, when a user has violated the community guidelines, then the platform will remove the user's post or even suspend the user's account. Once the platform modifies the user's content, they will explain what rules they violated and what post went against the community guideline. This can also help users look at what they did wrong and warn them for future content.
Why did Florida enact its social media law?
Florida's intention in regards to the media constriction law was to prevent the favoring of one political ideology and candidates over another. As many studies have shown, social media platforms seem to be constricting the potential audience engagement when political views are more right side centered. Essentially, posts prioritizing right-wing views and prioritizing left-wing political views as a form of self-branding. The core issue of these actions is the building prevention of individual views and development of not only political but ideologies as a whole based off of the regularly consumption of media.
What tier of scrutiny should the court review with Florida's law?
The court should find rational basis to be most frightening level of scrutiny within our case today, as social media should not be held at the same standard as other business, as it's built of third-party contribution on their platform and not simply taking constructive criticism and being sole control on their personal branding. Thus, making the law not have contribution on the fundamental rights of the First Amendment, the core of this law is in order to promote general welfare, meaning it would fall under the rational basis in which it would undoubtedly pass the provision of political favoring and deplatforming of others and would address through the media constriction laws, resulting in the two being rationally related, meaning it would pass with application of rational basis.
Do social media platforms resemble newspapers, which can control their editorial content?
Social media platforms fail to to resemble newspapers in a multitude of ways. First, although newspapers may be written by multiple individuals, these individuals work for the company that the newspapers will be released by, differing from social media platforms that are built off of third-party interaction within the platform. Moreover, individuals who engage on social media do not have the intention of creating branding or pushing an editorial goal on the platform itself in which they are uploading. Instead, they themselves use a social media platform in order to push or use a type of editorial judgment on their brand, which resides on the platform but is not the media's platform itself.
Do social media platforms engage in commercial speech?
Social media platforms are very helpful places for small businesses and other businesses in general. The social media platforms help spread their information and businesses. Social media platforms can also put ads of certain businesses. For example, on Instagram, when going through user stories, there will be ads in between studies of stories in between the stories of a product with information. However, if the speech does go against the guidelines, then the platforms would have no other choice but to interfere.
Will the Florida law increase or decrease free speech on social media?
The Florida law has created a increase in free speech. Since social media platforms do not have editorial judgment due to the advancements in technology, allowing people to upload content within seconds, social media platforms remove the content which is inappropriate to the public and beneficial to the community, such as right-wing or conservative views.
Does the Florida law create a slippery slope towards censorship?
No, it does not, as it doesn't create a harsh censorship law for social media to follow, as the community guidelines do not change on behalf of the state, but do comply with restrictions on possible exposure in a consistent manner.
Does the compelled speech doctrine protect the rights of social media companies?
No, Your Honor, it doesn't, because in this case the court should find social media platforms to not be seen as private actors. Therefore, simply asking them to not restrict right-wing or conservative views would not infringe on the compelled speech doctrine. It is for these reasons that we pray you will rule in favor of the petitioner and reverse the lower court's ruling. Thank you.